As it pleases the court, I pray for the state as it was.
May it please you, my lord, I appear for applicants 1, 2, and 3 as before.
May it please you, my lord, I'm still on record as before.
Here's the court. My lordship, on behalf of 5 and 6 as before.
Second Angela?
Yes, my lord.
You are still under oath?
Yes, my lord.
Yes, Mr. Patela?
Lord, I have a couple of agreements that I would just like to go through with the witness. Two of them.
You have sorted it out with your colleagues?
One should always be careful not to say completely, but yes, my lord, to the extent reasonable. We have done so. We have shared some of the homework with them. So I don't know if they can confirm with me.
Yes, Your Lordship, we received some documents. I hope it's everything.
The rest of the documents, my lord.
No, at times I wish I was a referee in a boxing match. Then I would have.
Yes, my lord.
Yeah. Because the jabs that are being thrown here. Yeah, all right.
Yes, my lord, the rest of the documents are contained into 2 bundles. One is the Lloyd report, which we have asked our learned friends to bring an extra copy of for the witness, and the other one is the state disclosure file. So we were quite transparent to the extent necessary, my lord, as it pleases you. The documents that I will deal with, at least the agreements for now, they are already, 2 of them are already exhibits before the court. It's Exhibit E.
Exhibit E.
Yes. At some stage, I'll also deal with Exhibit 8.2, 8, or Z. Sorry, my lord, is Z8.
Okay.
Yes, Z8.
This is J.
And the third one that I will deal with, my lord, is Exhibit J.
There is a file, an exhibit file of mine that's missing.
No, I have sufficient copies, my lord. I'll give you a copy.
Oh,
Yes. Lord, may I hand over the agreements? May the court orderly assist me with handing these extra agreements to Mr. Kanyangela. Thank you. It's in volume 2. Mr. Kanyangela, are you looking at Exhibit Z8? That is the designation agreement.
Yeah, I'm looking at that document. But my lord, I just feel I wanted to say something on what I was questioned yesterday by Mr. Patela. With regard to the powers given to the minister, with regard to this distinction of fish court, just to put the court in a picture of what has transpired, before these powers was given, or before the amendment of the Marine Resources Act, because yesterday I did not realize that what was questioned, or the sections that I was asked to explain or to read, they were not. I was not aware that it was part of the Marine Resources Act that was amended. That's why I want to put it, the court in the picture, as to how such powers were given, if the court may permit me.
You are testifying in cross-examination now.
Yes, my lord.
I cannot allow you in cross-examination to give your whole testimony all over. What I will do, I will allow you in re-examination to explain some of these things.
Yes, my lord.
Yes, but in cross-examination, I cannot allow you to testify afresh.
Understood, my lord.
Yeah. But in re-examination, you have the liberty to explain everything and to clarify issues that were not clear.
Thank you, my lord.
Yes, Mr. Kanyangela, are you looking at the designation agreement, Z8?
Yes, I'm looking at it.
It's an agreement between the Ministry of Fisheries and Marine Resources, represented by the then Minister Esau, and the National Fishing Corporation of Namibia, represented by the then Chairperson of the Board of Directors, Mr. Atupilipi. Is that correct?
That's correct.
It lays down the terms of this agreement. Is that so?
That's correct.
It records, at least there are recordals in the second page of that agreement.
Yes, I can see them.
And then it deals with the agreement, means this agreement that is contained in here and no other agreement. Would that be correct?
That's correct.
And Mr. Hatukulipi, when he acted here, he stated that he was representative of the board of directors. That's what the agreement says.
That's correct.
And he was exercising the powers under Section 5, subsection 1A, Roman letter 1, and Roman letter 2, bracket B and bracket C of the National Fishing Corporation Act of Namibia. Is that correct?
That's correct.
And would I be correct that these agreements were also gazetted?
That's correct.
They were gazetted for the whole public of Namibia to be aware of this agreement.
That's correct.
Meaning, would I be correct in saying, in argument, that each and everyone that has anything to deal with this company in Namibia is deemed to be aware of the contents of this agreement because it was gazetted, it was published for the whole world to see?
That's correct.
Did you look at Section 5, bracket 1, bracket A of the National Fishing Corporation during your investigation?
Yes, I look at it.
And what did you make of it when you looked at it, of the powers that are contained therein? Just briefly, you don't have to go into details. I know you are not a lawyer, but I need to put this to you so that we can then clarify the course of our engagement this morning.
I believe you can say that the minister is having the power
Yes.
to designate an entity.
Yes. Would it be correct that the board, duly authorized by a resolution of the board of directors, duly authorized Mr. Atukulipi to exercise all those powers that are set out in the facade of this agreement, on the first page of this agreement? This was what the board resolved, that he must exercise all those powers insofar as this agreement is concerned.
He exercised these powers He was representing the board to exercise such powers.
Yes, I agree with you.
And further, what I can say is that after the amendment of the Act, Mr. Bernard Esau, who was by then a minister, he wrote a letter to Mr. Hatuikulipi in which he instructed him that Fishrot must apply to have fishing quotas. In the same letter, he also instructed, or he advised, that Fishrot must apply to the same minister to be a designated entity to harvest on behalf of the state. I cannot confirm whether it was after such request by the minister it was discussed with the board. But I cannot confirm that.
That's all right, Mr. Kinyengel. Let's go back to my question. Would it be correct of me to argue to His Lordship that the board resolved to delegate Mr. Hatuikulipi to exercise the powers set out in that section insofar as the implementation of this agreement was concerned?
Yes, that is what is indicated in this agreement.
Yes. This agreement is a government agreement, is that correct?
That's correct.
It's fair to assume and to conclude that the government has a big team of lawyers through the Office of the Attorney General, is that correct?
That's correct.
They also have a big team of lawyers under that office. There is another department called the Government Attorney, is that correct?
That's correct.
And one can reasonably conclude that this agreement would also have been considered by the legal representatives of the government, is that correct?
That's correct.
If we go to the scope of the agreement, that will be on page 24. If you look at 24 at the top right.
Yes, I'm there.
Yes. Can you read that into the record, please? Under paragraph 2, the scope of the agreement.
The scope is saying, this agreement shall form the basis of the designation anticipated under Section 3 of the Marine Resource Act, through which the state shall utilize or harvest marine resources within Namibia's exclusive economic zone and its territorial waters to advance any social, economic, cultural, or other governmental objectives in the public interest.
Can you go to the designation under clause 3.1?
3.1 said, the minister hereby designates the corporation and its subsidiaries on the direction of Cabinet of the Republic of Namibia under Section 3, subsection 3 of Marine Act to, on behalf of the state, harvest for the state and to utilize the harvest marine resources towards social, economic, cultural, or other governmental objectives in public interest. Designation.
All right. Is it correct that in clause 3.2 it reads that the corporation accepts such designation and shall fulfill the objectives as directed by the minister from time to time?
That's correct.
There are other clauses of that pertaining to the allocation of the quota, the financing, confidentiality, entry into force, and duration. Is that correct?
That's correct.
It also provides that it can be reviewed and amended as the parties may deem necessary. Is that correct?
That's
Under
correct.
clause 8.
That's correct.
Particularly in clause 10, it records that this constitutes the whole agreement
That's correct.
between the parties, and that no other warranty, representation, or disclosure, expression of opinion, guarantee, etc., is relied upon in entering upon this agreement, and that it was made by any other party except the ones that are recorded in this agreement.
That's correct.
So if anyone comes, if you look at clause 10.2, it also says no variation of the terms and conditions of these agreements or any other purported consensual cancellation thereof shall be of any force or effect unless reduced to writing and signed by the parties.
That's correct.
So the parties agreed that their relationship shall be governed by one instrument and through this agreement. Is that correct?
That's correct.
The agreement in its designation makes it specific that the minister shall be the person that allocates the quota, that exchanges information with the Fisco in terms of how much they can harvest, etc., for governmental objectives.
That's correct.
And there is no other functionary like the cabinet that is referred to in that agreement.
No, it's not.
Insofar as you know this agreement, you have already testified that it was gazetted. But insofar as you know, this agreement was never challenged in court, reviewed, and set aside to this day. Is that correct?
Yes, that's correct.
Even the ACC has never brought this agreement under review in the court of law. Is that correct?
No, that is correct.
And therefore, we can accept that this forms part of the lawful relationship between the parties.
Yes.
Can I take you to the next one? It will be, maybe I can start, my lord, with, to start chronologically, maybe with Exhibit E. There are a lot of these agreements, Mr. Kayangela, that we have, you dealt with a couple of them. I believe it's just a sample of these agreements. Let's deal with the usage agreement. It's between two entities, is that correct?
That's correct.
And that would be Career Investments 180 and National Fishing Corporation.
That's correct.
It was concluded, this one, it was signed by my client, the applicant, Mr. Ngepunya, is that correct, in his capacity as the CEO?
That's correct.
If you look at it, it records in paragraph 4, clause 2, there are recordals that are set out therein, where Fisco allowed this company to use the 25,000 tons of its horse mackerel quota. Is that correct?
Which paragraph?
You see paragraph 2.3?
2.3.
The second page, page
Yes,
2,
that's
yeah,
correct.
towards the bottom.
Yes.
And it says that both parties had approved of this agreement and wished to enter into an agreement to govern their respective rights. You understand what rights are? Those are that are enforceable through lawful means if it's necessary. And the obligations that are referred to, is that correct? If you look at paragraph 2.4.
2.4.
Yes.
Yes.
Let's pass the interpretation because it's a clause that is there. If there is a need, we can always refer to it. Let's go to paragraph 5. In this agreement, Fisco expressly guaranteed that it had been allocated a horse mackerel quota for the quota period ending 31 December 2017. Is that correct?
That's correct.
We already know the amount of quota that was the subject matter of this.
That's
How
correct.
much was the usage fee that was set out in that agreement in paragraph 6.1?
The usage fee was 2,500 per ton.
Yes.
Namibian dollars.
And the method of payment is also set out in 6.2. You see that?
Yes, I can see that.
It tells that on the 31st of July 2017, 13,600 of quota shall be used, and the fee shall be 34 million. Is that correct?
That's correct.
There is also the payment that has to be made on 26 August 2017. You see that?
That's
In
correct.
the amount of 26,085,000. Is that correct? If you look to the far right middle of that table.
Yes, that's correct.
And on the 30th of September, there was an amount that had to be paid. 30th of September 2017, there was an 11,787,500 that had to be paid. Is that correct?
That's correct.
it was very clear what the parties agreed. They agreed that there shall be a quota that shall be availed, and this were the payment that would have to be made.
That's correct.
If we continue, there is also, the agreement also deals with levies and punishment for bycatch, etc. in paragraph 6.31. You see on page 8 of that agreement.
Yes, I can see.
Yeah, I want us to just move to the, there was also a clause on arbitration. What would happen if one of the parties was not happy with the manner in which the other one was behaving? Is that correct?
That's correct.
That they would take each other to a referee, an arbitrator that would then determine the dispute, etc. That would be clause 9.
That's correct.
All right. The agreement specifically required the parties under clause 10 to behave and act in good faith in the implementation of this agreement. Is that correct?
That's correct.
You do at least understand what the requirements or what good faith would require, that people have to be honest with each other.
That's correct.
All right. If you go to paragraph 12, it was very clear that this also has to be the whole agreement between the parties, and no agreement, representations or warranties other than those set out in this agreement shall be binding on the parties. Is that correct?
That's correct.
And also that there was no variation to this agreement unless if it was reduced into writing and signed by all the parties. Is that correct?
That's correct.
And that is the long and the short of this agreement. If you look at the clause 18 as well, it talks about the warranty to sign and the power to sign, etc. If you have an agreement like this that is so detailed on what each party's rights are, what is being availed, and so on, what do you think is the purpose of this agreement, an agreement like that?
The purpose of the agreement is to bind what was agreed upon.
So there is no lack of clarity in terms of what was agreed. Is that correct?
That is correct to me.
Yes. If we go to Exhibit J, it also bears the same hallmarks that we have discussed. Exhibit J is commercial fishing right harvesting agreement between National Fishing Corporation and Saka Seafood. Is that correct?
That's correct.
It also, if you look at page 2, the index there, it will almost have all the clauses that we have discussed in here. We can waste time going through them, or we can just summarize, but I can give you the assurance I'm not trying to trick you by saying it has clauses that it doesn't have. It's very clear on who the parties are to that agreement. Is that correct?
Yeah, that's correct.
It also is very clear in terms of what was the harvesting fee in clause 6.
That's correct.
The obligations of the parties are also set out in clause 7 of that agreement. Is that correct?
That's correct.
The default as well, what will happen if the parties disagree, as well as arbitration, if there are problems between the parties. Is that correct?
Yes, that's correct.
All right. Meaning each of the parties and their officials were quite clear when they looked at this agreement, what they had to pay for, etc.
That's correct.
That's why I think we have to then look at the statements of some of the witnesses that we have relied upon, who say that they were forced to pay for some monies that they had not agreed to. Because I find those statements quite strange in view of the parties' rights that were expressly set out in the agreements as to why somebody would try to agree to something that is clearly not only unlawful, but also that is outside of the agreements which he has rights to. Is my question clear enough, or should I repeat it?
No, it is clear.
Yes. So I find that strange. Don't you find that?
You see, it's a statement and it's long.
All right.
Maybe break it down.
Yes.
So that he understands.
All right. What I've said is that that's why, for me, I find some of the statements that you have in your possession that you seem to be relying on in this case, particularly the ones of Mr. Kamano and one of Mr. Luis Fernandez, to be quite difficult to reconcile with the clear agreements that are written here where each party knew what their rights are, and yet they say they were forced to pay for something else which was not part of the agreed.
Objection, Your Lordship. Reference is made to these two agreements and two particular witnesses, Mr. Kamano and Mr. Perez. Those witnesses are not parties to these agreements, Your Lordship, which have been referred to. There are other agreements for those parties, not these agreements. This is for the Icelandics.
But look, the point that I'm trying to make is that I said I took a sample of all those agreements, but we can go through them and spend the whole morning, to reach the same point.
Just address the objection.
Yes.
The objection is that the agreements that you have referred the witness to, Mr. Kamano and Mr. Perez, are not party to this.
Signatories.
Yeah.
All right, my lord.
Therefore, whatever statement they are making are not applicable to this
Right.
agreement.
I think that is a fair objection, my lord.
Right.
Yes, that is a fair objection. My starting counsel will pull out from the file those ones where those gentlemen have signed. But perhaps while we are looking for those agreements, we can look at on the file 1 or file 2. There is one at file 2. Yesterday, I referred to you that there were a couple of emails that were exchanged between ACC officials
That's correct.
and your office. Is that correct?
That's correct.
My lord, can I hand over this
Yes.
email of Mr. Fernandez of 14 November 2020? Yes. For the court. Did I give you a copy?
Show them to. Yeah. Okay, you give one to him and one to. Yeah.
Mr. Kanyangela, are you looking at that email?
Yes, I'm looking to the email.
You will be aware of this email because you were copied to this email.
I'm aware of the email.
All right. This email was sent on 14 November 2020, is that correct? By
That's
Mr.
correct.
Luis Fernandez.
That's correct.
And he had copied a number of documents in there. Unfortunately, some of those attachments, they were not discovered to us. But we can deal with the text of this email and try to understand. He wrote this email to Mr. Olivier, is that correct?
That's correct.
And he stated that I hope this will find you well. One more time, thank you very much for your patience. He then wrote as follows. On October 19, 2020, I proceed, and my lord, I'll read the email as it is, whether the English is correct or not. I proceed to send an email acknowledging receipt of requested documentation made between 15 October 2020 and October 16, which is provided in the following days by means of 11 emails between October 22 and 28. Is that correct?
That's correct.
Have those emails been provided to, in the state disclosure? Those emails that Mr. Fernandez refers to in that email message, to the best of your knowledge. I will not hold it against you if you have not done so.
I cannot 100% say, but I know the emails that was between him and Olivier, they were attached to Olivier's statement.
He says,
It is in the case file.
all right, he says the last day, October 28, and in response to my last email, an email is received from Mr. Willem Olivier in which it is requested that the documentation provided be summarized, which is done by means of the preparation of this document. Is that correct?
That's correct.
So Mr. Luis Fernandez provided this email in response to a request that had been made by the ACC.
That's correct.
That request had previously asked him to provide a certain number of documentation. Is that correct?
That's correct.
He provided that documentation and then he summarized it for you. Is that correct?
That's correct.
What did he say in regard to, when you look on the background, request October 15, he says on 15 October 2020, Mr. Olifir come to LK offices. Would LK offices be low-key investment offices? LK.
That's correct.
Located in Walvis Bay. Sorry, maybe I'm getting ahead of myself. Located in WB. What would WB be?
Always back.
All right.
Just indicated.
And in my absence, due to the fact that I've been attending to personal issues abroad, some requests are communicated to the receptionist of the company, which sends me by email and which are summarized in the following. Is that correct?
That's correct.
Then he deals with services delivered by a company called Wanakatu with all relevant documents, invoices, and payments. Is that correct?
That's correct.
What does he say there about Wanakatu?
He said Wanakatu is a company with which we contacted in our implementation in Namibia, given the lack of experience of our company in that country.
So he says they themselves contacted.
That is what he's saying?
Yes, they clearly contacted them for something. What did they contact them for? It surely was not to meet for coffee or for a beer. It must have been for something serious business. Is that correct?
Might be correct, but I cannot figure out which business.
Mr. Kanyangela, I'm not asking you for your opinion. I'm saying, what did they say in the email they contacted them for? Because this email was copied to you.
They say in our implantations in Namibia, given the lack of experience of our company in that country.
Can you go to the next paragraph? Because surely you have read this email before and you know the contents and you know where I'm going.
Not in my head.
All right, then read the next paragraph, please.
You say in this says LK structure at that time is almost nil, and the needs to handle itself in a country with such complex regulations could compromise the investment made in Namibia.
So they wanted, to navigate the business environment and complex regulatory system of Namibia. Is that correct?
That's correct.
They did this in order to protect their investments.
That's correct.
They are not saying they were paying bribes here. Is that correct?
They will not say.
Yes.
Yes.
So go to the next page. What did they say thereafter?
They say our business relationship lasts less than a year, mainly late 2017 and early 2018, and focused on advice and logistic support.
So it would be correct that if there is a business relationship between the two of them, one was providing services and one was paying for those services.
That is to be alleged in this document.
All right. He talks about the invoices thereafter, because you see what I struggle with is the perception that is being created that these people were paying for nothing. While the same person here, Mr. Fernandez, but we will deal with that.
Which ones, Mr. Kotela?
Wanakatu. The evidence in chief was that Wanakatu provided invoices for services that were not rendered. And here is the...
Oh, okay.
Yes, my lord. Here is the entity, that was tasked with engaging Wanakatu, and they are providing clear, information as the reason why they themselves contacted Wanakatu. Mm-hmm. So if we go to the next page, the next line, what does it say there? It says the invoices and proof of payment were already delivered, which are reiterated in this document as document number 1. Is that correct?
That's correct.
As I said, I don't have that document number 1, but I have the email. So perhaps one day when document number 1 is available, we can also engage with it if it's necessary. Insofar as the quota catching agreements and payments made, what would this low-key company, what does it say here? represented by Mr. Luis Fernandez. Paragraph 2.
Paragraph 2 is in response to your request, the agreements as well as the payments made were already delivered, which are reiterated in this document, document number 2.
Why did you not tell the court about the status of this email when you gave your testimony in chief? You know, to volunteer the information, you say, my lord, although maybe there could have been a subsequent affidavit, but initially this is what they had said to us as the ACC. Why did you omit this email? Did you think it was not important?
As I have indicated before, I was testifying on the documents prepared, and my testimony was based on those documents.
Documents prepared by who?
By the prosecution as the state's bundle.
Okay. You know what I struggle with? You have provided 80,000 pages of documents at this moment. Is that correct? Plus, minus 80,000. That's what, you know.
That is what being said. I did not
Yes.
count them.
You know what you are? The Deloitte team says is the volume of documents that are in your possession, which have not found their way to us to be able to engage with in order to prepare and defend our clients. Do you know?
Can you just repeat what you said?
Do you know how many documents Deloitte in its report mentions that they are available, but which we say have not been provided to us in order for us to be able to defend our clients in this matter?
But the documents was provided.
Not all.
I'm not
80,000 were.
I'm not the one who did the disclosure.
But you are the one that is on the witness box. I have to raise this with you, unfortunately.
So if it was not disclosed,
Yes.
it will not be ACC's baby.
All right. Let me do this. It is because the ACC is the one that is saying our clients are guilty.
No, we did not say they are guilty.
And yet you are asking us to go into battle to defend our clients with our hands tied behind our backs. Because let me just tell you how many documents the report says they are available. Paragraph 2.21 of the Deloitte report. Second sentence, it says, as at the date of this report, the total number of files or documents loaded and available for review on relativity was 683,658. And the total size was 196 gigabyte. Why were these documents not provided?
Then I think when we realized that we were supposed to ask the prosecution.
I'm asking you.
I have submitted to the prosecution.
They don't answer to me. I ask you because you are the witness for the state.
I don't know why it was not.
But you agree with me. This is what they say in the report.
Yes.
You can read it if you have problems.
I don't have any
And that's
problems.
why we really are struggling, because the ACC seems to be on a pattern.
So what I'm saying, ACC is not the one to disclose such to you.
But the ACC is the one that is saying our clients are guilty based
We are not saying they are
on less
guilty.
than 10%.
You are now in a debate with a witness.
All right, my lord.
So just ask him the question. He has answered you.
As it pleases you, my lord.
So
As it pleases you, my lord. I put it to you that the ACC is so desperate to prove our clients guilty by hiding the bulk of information which is likely to help our clients and disclosing only a small portion in order for our clients to look bad in this matter. Is that correct?
ACC never heard anything from you.
Yes. And the ACC has not assisted this court. I put it to you that the ACC has not assisted this court to make sure that all the available documentation is before this honorable court.
All the documents that the ACC gathered or collected during the investigation, they were provided. Lord,
page 10, paragraph 2.21 specifically,
Page 10 of what?
of the Deloitte report, be admitted as an exhibit. I believe it will be CC. No, just that page. Yes, page 10, only page 10, my lord.
Yes.
You have it, my lord.
That's paragraph 2.
Only
It's
this
that-
page, my lord.
Yeah, no, but
Yes.
I just want to verify with you.
Paragraph 2.21.
2.21.
Yes, it pleases, my lord. But my learned friend is on his feet. Maybe he has an objection.
There's no objection, Your Lordship. Just to place on record that all the documents received have been disclosed in this particular case, Your Lordship.
Let me finish with this email. Can I take you to the same email that we are still going through? From Mr. Luis Fernandez, paragraph 7 of that email.
Yes, I'm there.
It would appear when one looks at that email that Mr. Fernandez was not saying what he said in there for the first time. Would that be correct?
Let me read.
Judging by the first four words of that paragraph, paragraph 7. Maybe to save time,
Yes,
Mr.
to mention
Kanyingela.
something else.
Yes, Mr. Kanyingela, can you read the first paragraph of that item number 7?
said-
Explanation regarding Wanakatu services.
It said, as we previously said, in the year in which LK was established in Namibia 2017, we were aware of the nil experience we had in key aspects of the fishing business in the country. We were unaware of the operation of basic elements, such as the location of public agencies, fishing agencies, auxiliary logistics companies, or supply companies. All these are basic aspects in the fishing sector, and that can only be managed locally.
Would that be the reason why they conducted Wanakatu services?
That is what he's saying.
Yes. He talks further as well in that paragraph. What does it say in the second paragraph? At
He
that
said
time,
at that time we had the services of this company. Although after just 1 year of a relationship, we decided to break relation with them.
so he confirms that they actually went ahead and hired Wanakatu services. Is that correct?
That is what he said.
So this will be contrary to any information that they say they do not know what Wanakatu was. Just reading by this
I
and
might
comparing.
say, during these communications,
Yes.
I might say that
I'm saying, looking at these two, if any reasonable person looks at these two, clearly they admit that they had a business relationship, and for what that business relationship was with Wanakatu,
yeah, that is what is this.
yes. I'm glad to see at least we agree on some things. He then goes ahead and provides the documentation there, that is document number 3, is that correct?
That's correct.
He then say, paragraph under first request of October 2016, is that correct?
That's correct.
He then mentions that on 16 October, Mr. Olifir comes again to low-key offices and proceeded to extend the request of the previous day which are again transferred by the company's receptionist by email to the following terms. He wants written agreements and services delivered by 3 companies. Is that correct?
That's correct.
Which are Fine Seafood Investment Trust, Njako Investment, and Kwanyamba Investment. Is that correct?
That's correct.
He then said both Fine Seafood Investment and Kwanyamba Trust are companies which we have never had a commercial, business and financial or other relationship. Is that correct?
That's correct.
But then he says something else about Njako as well as Fine Seafood. Is that correct?
That's correct.
What does he say in the middle paragraph?
He said, however, and although it is not required, we have had a commercial relationship with the company Fine Seafood CC. We do not know if it is an entity related to Fine Seafood Investment Trust. Since we have sold fish mainly by cash, or this is accredited by the attached documents number 4.
So he provided documents of the sales of the buy cash fish to that entity. Is that correct?
Yes, he did provide.
All right. Regarding Njako Investments, what did he say there?
He said the agreements signed with this company are provided as document number 5.
So there were also agreements that were concluded with Njako Investments.
That's correct.
And they were signed. Is that correct? Mr. Kanyangela, please don't be surprised. You have read this email before. You know about this email. You know where I'm
I know
going.
the email, but as I said, I deal with a lot of documents.
Yes.
And you cannot expect me to remember everything in every document.
All right, I'll remind you.
Yes, this agreement was signed.
Would that be an agreement that appears as LF6 in your disclosure? Sorry, if you can give it to the... Yes, well, I have another copy, but I'll share it with you. Yes. Would that be an extra LF6 that was provided to you by Mr. Fernandez?
Yes, this is an agreement.
All right, if you go, does that agreement set out the terms of the relationship between these 2 parties, Njako and Loki? Mr. Kanyangela, does this agreement set out the relationship between the 2 parties here?
That's correct.
This agreement surely was part of the record of the ACC.
That's correct.
And yet you testified before this court in your testimony in chief that there was no signed agreement between Loki and Njako Investment. You recall saying that?
That's with regarding to the harvesting of marine resources.
No, you didn't say, you didn't qualify it. You said there was no signed agreement between those parties. And this is disturbing me.
And I cannot recall of what you said it.
All right. But if you said that, if the record, we go back to the record and we find that you said that, would you retract given the opportunity? Because here is a signed agreement that was copied to the ACC.
Because if I testified about it, and it was part of the bundle, I don't know why I will say that there was no signed agreement.
All right, let's go. Here is the signed agreement, but you can confirm now that here is a signed agreement between these parties.
Yes.
And it was signed on 1st of January, or January 10th, 2018. Is that correct?
That's correct.
Yeah. If you look at this agreement, what does it say about the service that had to be provided by Njako under paragraph 4?
Paragraph 4 is saying, Loki Investment Pty Ltd hereby appoints Njako Investment CC as the service provider, and Njako Investment CC accept the appointment, subject to the terms and conditions set out herein.
What was the duration, the period of this agreement in clause 5.1?
It was a fixed term of 2 years.
Can you go to the services that had to be provided under paragraph 6?
Under paragraph 6, the services to be provided is indicated as provide consulting services, then provides vessel management services, then provide vessel repair and maintenance services.
All right. Let's itemize them, because I think it's important for the court to have a view of what were the, when we refer to consulting services, what exactly was meant in terms of this agreement. It was market prospecting and research services in Southern Africa, especially Namibia and South Africa, as well as encourage business relationship of African companies with the European market. Is that correct?
That is what you're saying?
This would be a massive task to undertake, to research throughout Southern Africa and Europe and create business relationship. Would that be fair to reach that conclusion?
Yeah, that's correct.
Yes. To provide reports on the political, labor, financial and social situation in Namibia and how it can impact those in low-key development of business activity. Is that correct?
That's correct.
Also, it was to provide reports related to other areas of the food sector beyond the fishing industry, such as meat and agriculture. Is that correct?
That is what it's right.
And then general regular country risk reports. That would be correct too.
That's correct.
It's a true reflection and correct reflection.
That's correct.
Insofar as the vessel management services are concerned, what were the services that Njako was engaged to provide by this company?
The set of studies and report on new vessels that can be incorporated into the low-key fleet, prepare regular reports on the behavior of the fishing industry, and application and adoption of the company's resources to the optimization of effective hake fishing in the Namibian fishing ground, then holding regular face-to-face or teleconference meetings to analyze the evolution of low-key's fleet performance.
And insofar as vessel repair and maintenance services, what was the task of Njako?
The task was regarding to reports and meetings, focused in the ensuring that the vessels are well managed and repaired and in a good fishing conditions, as set by the relevant authorities. Reports related to repair work, maintenance and optimization of the ship, all of the processing and freezing tunnels, and provide the necessary reports and meetings with requested to do so from time to time.
Would I be correct that insofar as this agreement is concerned, it also provided the scope of services and service fees to be charged in paragraph 7
That's
or clause 7?
That's correct.
And it was clear that Low-key will pay the consultancy fees upon presentation of the invoice by Njako on the rates agreed. Paragraph 7, second paragraph, or clause 7, the second paragraph. Is that correct?
That's correct.
It also had a provision for how and why the agreement would be terminated. Is that correct?
That's correct.
And if we skip, it had specific clear line for disputes in clause 10, how disputes are to be resolved.
That's correct.
It also had clause 12. What does clause 12 tell us?
Clause 12 is headed governing law and jurisdiction. This agreement shall be governed by construed and interpreted in accordance with the laws of Namibia. And each of the parties irrevocably agreed that the courts of Namibia shall have jurisdiction to hear and determine any suit, action, or proceeding, and to settle any disputes which may arise out of or in connection with this agreement.
What does it say about, in the clause headed general, which is the final clause of that agreement?
The final clause is saying this agreement contains all the terms and conditions of the agreement between the parties, and no representations, warranties, undertakings, or promises of whatever nature which may have been given by one party to the other than as herein contained, shall be binding or enforceable by any party against the other, and no variation or alteration of this agreement shall be of any force or effect unless it is recorded in writing and signed by both parties.
Would it be fair to then conclude that Njako will be entitled to provide invoices relating to services that are set out in clause 6 under this agreement?
Yes.
My Lord, may this agreement be marked as exhibit?
Is it not?
It's already before court, isn't it?
It's already before court.
Yeah.
It was attached to a statement of Mr. Perez.
No, the
We've
statement
dealt-
of Mr. Perez was not admitted because we had issues with it. So I don't know, my Lord, you can give us guidance. We have objections to that statement because we said it's not a statement, it's not an affidavit, that it purports to be, it's not commissioned, we don't even know when it was signed, etc.
Yes, it was not submitted with a statement, individually, provisionally by the court, as far as I can recall.
So, my Lord, may it be exhibits
Wait,
CC?
let me see what it is an exhibit. If you read 683,000 pages, you want me to read them also?
My Lord, I've only been provided 80,000. I'm still crying for what is in the other 500,000 pages.
See. I have an exhibit Z42, Roman 14. You see, they were submitted not together, they're under, but they were being referred to individually.
All right, my Lord. If they are referred to individually, I can live with that.
Yeah, it's Z42, Roman 14.
As it pleases you, my Lord.
All right.
All right, Mr. Kanyegela, let's go on with the email that we were dealing with before we diverted to that agreement.
Sorry, Mr. Patella, let me just quickly just get clarity on the question. I don't know what the answer was. You are saying this witness did not refer to this agreement. How did it then get into evidence as an exhibit?
The testimony of the witness, as we understood it from the record, was that they could not find any agreements entered into between Njako, yes, and this company. And if I'm wrong, my Lord, the record will reflect that.
No,
yes.
you see,
and it was on the basis that I'm interrogating that part
yeah,
to assist him to change.
That agreement,
Yes,
what I'm seeing What I'm seeing is it was an agreement, an invoice, and what is it? What is it? Notification of payment. That's the
sequence.
Yeah, the sequence in which they were being submitted.
All right, my lord. If that is on record, my lord, I'm willing to retract it.
Okay,
Yes.
Okay.
But the reason I wanted to raise that so that I give the witness the opportunity to deal with the witness so that we don't.
What I can remember, the witness said is, it's a few weeks ago.
Yes, my lord.
Yeah, every fallible human being would not remember. But what I can remember is Mr. Perez coming and disclaiming and disowning the services. No, not this witness, but they were referring to an affidavit by Mr. Perez.
All right.
Yeah, that was saying,
yes,
we did not receive any service from this. He was that statement was being read either
Into the
from
record.
an affidavit or from a document that was sent, and not really these witnesses.
all right. My lord, we will also try to put that into context.
Yeah.
Because there is some interesting information that we want to bring to your attention pertaining to that immediately after this email.
Okay.
Yes. So, but my lord, I take note of what you are saying. I'll live with that.
Yeah.
But in the end, at least even if the witness did not say so, he agrees with me in the record, then I have it at least provided, and then I can argue it at the end of the day.
Okay.
Because I wouldn't like the witness to be recalled just to come and argue, to ask him that question alone. All right, my lord, thank you for the assistance and the guidance. If we go to paragraph 10, Mr. Kanyangela, of the same email, you see the paragraph 10.
Yes, I see the paragraph.
What did this witness or Mr. Fernandez say in that email?
He's saying, as we have already established in points 1 and 7 above, LK's structure was very narrow, and in addition, we had lack of experience in the Namibian fishing business, so it was essential to have advice, logistical support, and medium long-term development assistance. The end of relations with Wanakadu at the beginning of 2018 took us to enter into commercial relations with Njako on those dates, as is proven in the agreement provided in point 9 of this document.
That would be the same agreement that we have just
Yes, correct.
looked at, all right. He then went on to say the second request was made. Who made that second request, according to that email?
I made the request
Yes,
of additional documentation.
yes. So you also came in and made additional request after Mr. Olivier.
Just correct.
Why didn't Mr. Olivier make this request? Why did you deem it appropriate as his supervisor to now come in?
I just found that there were some documents which he did not provide it.
All right,
That's why I sent him that request to provide the document.
all right. You asked him to explain documents in relation to the following payments. Is that correct?
That's correct.
These payments, all of them would amount to about 15 million, if my numbers are correct. I don't rely on that number, but they are here on the...
Yes, they
They
are
are from
listed today.
item number 1 all the way to item number 7.
That's correct.
Item number 1 is an amount of 3,450,000,
That's correct.
dated 3 of July 2018. Is that correct?
That's correct.
The second item is 862,500, dated 30 July 2018.
That's correct.
The next item is 2,875,000, dated 30 January 2019. Is that correct?
That's correct.
The same amount again as the one that I have just dealt with on 8th of March 2019.
That's
correct?
correct.
And the next one is 4,025,000 of 10 May 2019.
That's correct.
Then the next one is 1 million on 13th of May 2019.
That's correct.
Concluding with the 725,000 on 14 May 2019.
That's correct.
What did he say in regard to the services that were provided regarding these invoices?
He said the services provided and the invoices are consistent with the agreement signed and provided. Point 9.
He then dealt with a check that was missing of 12 March 2018 in the amount of 3,881,250. Is that correct?
That's a missing payment here.
No, he sent a check. We have checked a missing payment on the above requested. But we attached the proof of payment with the rest of POPs. I don't know what POPs are. Would that be proof of payments?
That's correct, yeah.
As document number 6, is that correct?
That's correct.
Right. He also talked about an individual called Eduardo Ferreira. Is that correct?
That's correct.
He provided that he has no evidence of Mr. Ferreira's involvement in the services provided by Nchago after reviewing their records. Is that correct?
That's correct.
But he says, however, we must state that the low-key relationship with that company was always true and only with Mr. O'Neill Nanentoka, and the people who might eventually work for him or for Nchago have never been brought to the attention of LK. Is that correct?
That's correct.
He apologized for the delay.
That's correct.
My Lord, may this email be exhibit
DD.
DD. There was subsequently an email on 18 January 2021. I believe it's 18 January, but it's in Spanish in the heading. Is that correct? I don't know if you have a copy. Q2.
Don't have a copy.
Let me provide you with a copy.
Q2.
Yeah. Exhibit Q2. I give him one. Lord, I have 5 copies of this email.
Yes, I have a copy.
But they have mysteriously...
Sorry, Mr. Patella.
Yes, my Lord.
The Q2 you are referring me to, right? On my record, it's the document that we have just marked as DD. That's the email from Luis Fernandez dated 14 November 2020, and it has all those issues that you... And now my file indicates that it's exhibit Q2. So it was already an exhibit.
What is yes, my Lord, that's what we say. It was already marked as Q2. DD, so we want to now look at the one of 19 January.
It's that one, the one of 19 January 2021, sent at 07:49 p.m. That's under, it's part of the affidavit of Mr. Oliver, and it's exhibit Q1.
My Lord, may I get some little bit of time? I need to sort out, because
All right, maybe.
I brought a bundle of all these documents with me.
Yeah.
So
maybe,
now they are flying over and...
So I will expunge exhibit DD
Yes, please, my Lord.
from the record, because there is already an exhibit Q2. Maybe I'll afford you 25 minutes for you to go and sip your tea, coffee, and then also
Yes, my lord.
to put your documents in order.
That will be, I mean, data to his lordship, my
All
lord.
right. Mr.
Thank you.
Kanyangala,
My lord,
you are reminded to be under oath and you are admonished as I normally do. You understand?
yes, my lord.
That you are under oath, you
Yes.
may not talk to anybody on this.
Yes, my lord.
Yes. I see you talk to yourself a lot after. This is why you realized some things. All right.
I'm talking to myself.